Hi, everyone. Doug Portnow from Schwegman here, and welcome to our webinar today on inventorship and assignment. And before we get started, Ryan, if you could just flip to slide 2, a couple of housekeeping and admin details. We will be recording today's webinar, and at the end of the session, we'll be happy to email links to all the registrants. If you have any questions today, please type them in the Q&A box, and we'll try to address them real time or at the end of the presentation. And don't forget to follow us on either LinkedIn or on our website to check out and see what other interesting webinars and information and educational things we have. Ryan, if you could go to the next slide. A little bit about myself. I'm Doug Portnow, and I'm a registered patent attorney at Schwegman. My practice focuses primarily on medical and mechanical devices. And before entering the practice of law, I was a medical device engineer in the device industry for about 10 plus years. My background's in mechanical engineering. Ryan, would you like to just introduce yourself quickly?
Yeah, I'm Ryan Connell. I'm an associate here at Schwegman. My practice focuses on chemical arts as well as mechanical. Within the chemical arts, I do industrial-based applications, chemical engineering, materials, pharmaceuticals. In the mechanical, I've done anything from gas turbine engines to medical device. Before going to law school, I earned a bachelor's in biochemistry, molecular biology, as well as chemistry, and then took up a master's in organic synthesis. So today's talk is going to focus on two aspects of patent law: inventorship and assignment. And I guess to kick it off, Doug, would you mind talking about the difference between inventorship and assignment and the relevance of each to patent law, please?
Yeah, definitely. So if you could just go over to the next slide, thanks. So I think just to get started, we should talk about, why is inventorship relevant? And to understand that, we have to go all the way back to 1789 in the US Constitution. And the Constitution in Article 1, Section 8, Clause 8 actually reads to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So what does that mean? What does that translate into? So the courts have interpreted that as the Constitution giving the US government the rights, the power to grant patents and copyrights to authors and inventors. So writings, when at the last portion of that, writings would be referring to copyrights, and discoveries is referring to patentable inventions. So it's interesting that it talks about discoveries and not inventions, but that's a whole nother discussion. Anyways, if you could go to the next slide. So why is this all relevant? Okay, so the Constitution gives the US government the right to grant patents to inventors, right? So that's what Article 1, Section 8, Section 8, Clause 8 states. And then inventors they own something. They own the rights to their invention. They can then assign those rights to another person, another company, another entity. So they can get some compensation for that. So what does that mean? That means patents are property. They can be owned, they can be exploited, they can be sold, they can be licensed, just like any other property. So the mechanism for transferring ownership is the assignment process, and that's why that is so relevant to today's discussion. If we could just go over to slide number 8 next, thank you. So we want to also just clarify that inventorship and assignment are really two different concepts. So assignment is the process of transferring ownership. And whoever the owner is of that patent or that intellectual property, the owner enjoys all the rights and benefits that are provided by that patent. In patents, the inventor is usually the initial owner of the patent because he or she is the inventor. But then under modern times, modern conditions, we're probably all employees of companies or faculty, staff at universities. So we're usually, at least in the US, typically obligated to assign your rights to your employer. So again, the mechanism for doing that is by assignment. So the inventor assigns his or her rights to the patent to the employer, and therefore the original inventor, the original owner, no longer enjoys the rights of those patents. Okay, if we could just flip over to the next slide. And we'll talk about inventorship later in the presentation about, what that means and what the standard for determining inventorship is. But a couple of relevant topics that we're not going to get too much into today are assigner estoppel. So again, that concept broadly is that the assigner of a patent is estopped or prevented from challenging the patent the patent validity during litigation. And before this summer, that concept or legal theory was very broadly interpreted, meaning the assigner basically could not challenge the validity of a patent. But recently, in the Minerva case, which came down from the Supreme Court this summer, the Supreme Court limited that doctrine to just any express or implied representations that were made about validity at the time of the assignment. So the scope of assigner estoppel has been limited. There's another concept on the next slide that is called a licensee estoppel. And in some jurisdictions, a patent licensee, so again, we're talking about a license, not an assignment. The licensee, meaning the person who is paying money to obtain rights or to use the patent, is estopped from challenging the validity of a licensed patent. And that was the case in the United States until 1969, when the Supreme Court overturned this doctrine, and that was in the Lear v. Atkins case. So a licensee now is capable of challenging the validity of a patent. So with that, I'm going to let Ryan talk a little bit about what or who is an inventor. But before we do that, I just see a couple of questions and comments in the chat, so maybe we could address those. Can we download the slides? We'll send a link to the recording that you can see. If you want a copy of the slides, if you could email us, we would be able to provide that for you. Oh, I see that Michelle already answered that question. I should pay more attention. Sorry, Ryan, back to you.
No worries. So yeah, so let's dig into inventorship in a little bit of detail. And perhaps the most pertinent question, at least for the purposes of patent law, is who is an inventor? Because determining who an inventor is has some pretty significant consequences in terms of what can be done with a patent. So when we think about an inventor, there's a whole bunch of concepts that might come to mind. But at least for the purposes of U.S. patent law, an inventor is a very defined legal standard. And in the U.S., it comes down to being a person who contributed to the conception of the claimed invention. Within that definition, conception is a loaded legal word, and it's a little bit wordy. I'll just quote it from the MPEP, then we'll talk about it a little bit more. But conception is defined as the formation in the mind of the inventor of a definite and permanent idea of the complete operative invention. It is thereafter to be applied in practice. In other words, it simply means that to actually have conceived of something, the person must have their idea in their head in such a manner that's clear enough that they could articulate it to somebody, not only what it is, how it works, and ideally be able to articulate it to such a degree that somebody of reasonable skill could take what they say and make, use, or practice the invention. Essentially, what it means is that you've come up with the idea in such a manner that you have control over it, that you can articulate it well. It's kind of the difference between, somebody, say when COVID broke out way back when, saying, boy, COVID's a problem. There should be a vaccine. I've invented it. Versus COVID's a problem. There should be a vaccine. Here's how it could work. Here's how you make it. Here's how you use it. That's an overly simplistic example, but it shows the difference between just having some wishy-washy, not well thought out idea versus actually conceiving of something solid that is useful and justifies your designation as being an inventor. One kind of interesting quirk, if you're not used to dealing with this, is there's a misconception about some folks who aren't as familiar with patent law that to be an inventor, you actually have to make your invention or reduce to practice, to use the legal terminology. There is no such requirement. Conception really only requires you to be able to articulate it in words, in writing, whatever. You don't have to actually reduce it to practice or make it to be considered to be an inventor. One thing to keep in mind, and this this is an interesting quirk too, if you're not familiar with this, that an inventor is determined by looking at the claims of your patent application or issued patent. That is, the inventor is somebody who's contributed to the conception of a claim. Whatever else is in the patent application, detailed description, drawings, abstract, doesn't matter. It's really just the claims that you're looking at to make the determination of who is actually an inventor or not. Do note that in some countries, you actually do look at the balance of the application, but for the purposes of US law, it's claims only. Oftentimes when you're coming up with an invention or building a new device, application, whatever, there's more people to it than just the folks who conceived of the idea. You might have technicians, machinists, graduate students, postdocs who actually help to execute your invention in that they reduce it to practice. But it's important to remember that just because they had a hand in actually building your device or executing a method, that doesn't make them an inventor for purposes of US patent law. It goes back to simply being the person who conceived of the idea, not who builds it. This can be illustrated in an example we have here where, say, you come up with a new part design, you draw out the plans, draw out the schematics, describe the protocol for making it, and then give it to a machinist who builds it just as you told them to. That machinist, while incredibly important in reducing your idea to practice, isn't an inventor for purposes of patent law. A twist on that might be, though, if the machinist actually modifies the part during the reduction to practice, say he or she figures out a tweak to make it more efficient, make it better, anything, and they conceived of it, and then their tweak or modification makes its way into a claim, that's when that person could go from not being an inventor to being an inventor. So that's something to keep track of as you're actually reducing something to practice. And that's where, good lab notebooks or documentation can be very important should inventorship ever be the subject of a dispute. Keep in mind that an inventor, that there can be multiple inventors for any set of claims, and it doesn't require equal contribution. One inventor could be responsible for 90% of the subject matter of the claims, whereas another inventor is only responsible for 10. They're both an inventor and they both have the same interests in the ultimate patent application. You only need to be an inventor for one claim that makes its way into the patent. One kind of trip up I've noticed sometimes is folks conflate the rules for authorship of a journal article with inventorship. Again, journal articles tend to be inclusive, right? You include, in the academic sense, right? You might have your primary investigator, graduate student, postdoc, undergrad researchers, lab techs, and everyone, rightfully so, is named an author on the paper if they had a hand in the research. But you have to, if you turn the subject matter of that paper into patent application, then you have to go through that list with a careful eye to make sure you understand who actually conceived of the idea versus who was just acting that direction. So keep that in mind, that you don't just port over the list that you would for an academic paper into inventorship. Do keep in mind, at least for the United States purposes, a company is not an inventor. Inventorship vests in individual inventors. Doug's going to talk about artificial intelligence. There's some case law on that. If you ever do have a dispute about inventorship or need to look for guidance, inventorship is a federal law issue. You don't look to your individual state's law on inventorship. So yeah, with that in mind, Doug, do you want to talk about AI and some more kind of exotic cases of who can or can't be an inventor?
Oh, sure. Yeah, definitely. Just a couple of things that are in the Q&A or chat. Someone asked if inventorship definition varies by jurisdiction. How do you take one patent application from one country to another? That's a really good question. And in some cases, there can be, differences in inventorship from jurisdiction to jurisdiction. I had one patent where in the US, there was a certain inventorship, and then in Europe, there was a different inventorship. Some jurisdictions, the definition is broader, in which case you're, certainly able to accommodate that, where, in the narrower jurisdiction, you can list the limited number of inventors, and then in the broader jurisdiction, you can have a broader list. but yeah, that's basically a question. The point is that you may have to have a different inventorship based on the jurisdiction in which you are operating. There was another question or comment about, is it wise to document it, who invented what claims, or might that be a problem? I think some people do that. I generally do not. I typically, before we file a patent and before a patent is issued, we review the claims with the client to make sure the inventorship is correct. And if there are, any names that need to be adjusted at the time we make changes, but we typically do not memorialize that. I don't know, Ryan, do you memorialize inventorship in any of your cases?
The only, not as automatic. The one time I did it was there was a company who had two of their subsidiaries working on an invention through a joint agreement, and there were quite a number of inventors. So just to kind of keep things clean during the lifetime of the patent, we did document who from what company dealt with what claims, so that as the application evolved through the course of prosecution, we could update inventorship accordingly. And the idea being that if that would impact ownership between the two subsidiaries down the line, we just wanted to have a record to deal with that at the time. So that's really the only time. Or if there's just simply a massive list of inventors too, it's good to keep track of that. But if it's just a kind of run-of-the-mill case, typically not.
Okay, yeah. And the only other time that I've really kept very careful track of inventorship is when there's been litigation involved. We want to try to identify, which inventor actually invented which claim, because obviously that has important implications for depositions and things like that. So, but anyways, let's move on to some AI questions. So I guess I'm the perfect guy to talk about AI, because some people have accused me of being artificial and not having any intelligence. So, but don't, right? There's the drums. Anyways, so a couple people have asked in the chat window that, whether how you handle other inventors. Can AI or machine learning be a named inventor on a patent? Well, I guess the answer is it depends, typical lawyer answer. And it depends, what jurisdiction you are operating in. And the case law has been inconsistent. So this summer in South Africa, an AI entity named Davis, device for autonomous bootstrapping of unified sentience, was listed as a named inventor on a South African patent. That was directed to a food container that was designed based on fractal geometry. So if you ever seen, like soap film patterns, that's kind of how that works. South Africa is a registration jurisdiction, so there's no actual patent examination. You just simply register the patent there. The patent is considered valid unless a third party challenges the validity. So stay tuned. We'll see what happens in South Africa with that. Also, that same patent family was also filed in Australia, and an Australian federal court also held that AI, the same Davis entity, could be a named inventor for a food container as well as a signal beacon. And then on page 7, slide 17, we move over into Europe. And in the European Patent Office jurisdiction, the EPO has said AI cannot be an inventor. And there were 2 denials of that in 2020. And very recently, we had the Thaler case in the US, where a US district court in Virginia held that the inventor must be a human, cannot be an AI. So again, someone commented on this in the chat box, is, how can you have the same patent in different jurisdictions with different inventorship? Well, again, it depends on the rules for inventorship. In the US, as Ryan pointed out, inventorship is determined by the claims. In some other jurisdictions, inventorship is determined by the teachings or disclosure in the specification. So that might be a little bit broader inventorship. And then we have this issue or this tension that, if in the US, if AI is an inventor, but can't be listed an inventor, and we know that you have to list the correct inventorship for a US patent to be valid, then how can that US patent be valid? Well, I'm not going to answer that. I think our audience can think about that and figure that one out for themselves. And then how are the rights to the invention handled if AI is an inventor, right? Can the AI assign the invention to the company or to someone else? And how is that actually handled? So you've got to look at the law in each jurisdiction. Some laws actually specifically refer to human inventors, or some typically refer to, use pronouns like he or she as the inventor. So presumably that means that the inventor is a human and not an AI entity. Some laws require mental conception, such as, again, the US. So that would seem to imply that inventorship is based on a human. Okay. Next slide, Ryan, please. One thing that we are often asked about is, well, you patent attorneys, you work on these patents, and shouldn't you be an inventor? Well, the answer, again, it depends on what you do. If you're just simply a pipeline or a conduit to the inventors and taking their technical information and drafting a patent application and translating all of that technical information into, we'll call it patentees, and drafting claims, then no, you're not. But if the patent attorney starts, contributing his or her own ideas that end up being in the claims, then it is possible the patent attorney could be an inventor. And so patent attorneys sort of, rather than being inventors on their clients' patents, they may ask, does your invention perform X, or does it do Y, or does it include Z? And then the inventors can answer those questions. And that way it's a little bit prompting, but I think that addresses, that way the idea is really coming from the inventors. And then there was a case, the Solomon versus Kimberly-Clark Corporation case, where the Federal Circuit held that the patent attorney is not an inventor if you're just prosecuting the patent application. Okay. On slide 19, we do talk about how patent inventorship can definitely change during prosecution. So very simple example here. You file your patent application with claims 1 through 20 and 3 inventors, A, B, and C. During patent prosecution, maybe there's a rejection, maybe there's something that needs to be addressed, and you have to amend your claims to distinguish the claimed invention from the prior art, or you are canceling claims or adding new claims. So again, because inventorship in the US is determined based on the claim language, inventorship may change based on those amendments. So as inventorship changes, you may have to amend the inventorship on the patent application. And then another issue that we talk about on slide 20 is the order inventors. So does it matter? Well, so, everybody wants to be referred to, on the patent as the Smith 123 patent or the Jones 456 patent. If there's ever litigation, that's typically how these things are referred to. But if you have a situation where the inventorship is listed as, let's say, Smith, Jones, and Doe, and you compare that to an inventorship that's listed as Jones, Smith, Doe, so we've switched the first and second inventors in that case. Is there any legal significance in that? No, it's the same inventorship, just a different order. And inventorship, permutations and combinations of inventorship don't really matter as long as it's the same. But in reality, yeah, we all have, our own ego. There's politics and things like that. So it would be nice to be the first named inventor on a patent, and you certainly can move the inventorship around, the order of inventors around. I can tell you one case I had where the first inventor left the company, and it was kind of like an unpleasant departure. So that company decided to move that inventor down out of his number 1 spot down to the bottom. So they weren't happy. So yeah, you can do that. There's no legal significance in that. But, if you want to spend the time and money on filing papers, you can certainly do that. Okay, well, let's see. Ryan, you're going to do some hypos? Oh, I'm going to do some hypos, right?
Yeah, and we've got a couple questions in the chat too, if we want to
Yeah, why don't
take
we?
a look at those before.
Okay.
Yeah, with the order of inventors too, I have some clients, companies who they just have a corporate policy of they list in alphabetical order just to sidestep those issues. Yeah, so starting up top, some of these were answered in the course here. There's one, could you please give an example of a patent which lists different inventors in the US and EP cases, provided the claims are essentially the same? I don't have one on off the top of my head. I don't know if, have you encountered that, Doug?
So again, in my understanding, so I'm a US practitioner, I'm not licensed in Europe, but my understanding in Europe is inventorship is determined based on the teachings and disclosure of the specification, not the claims. So it is quite possible that, in the US, if you claim, an invention X, but the specification discloses inventions X, Y, and Z, that the European application would have more inventors than the US application. So hopefully that answers that question. I can't give you a specific patent number off the top of my head, but we have seen that.
Yeah. There's another one asking if there are particular risks in over-inclusion of inventors, provided even if they're all from the same company and have the appropriate employment agreements. I mean, you want to, you can't lie about inventorship. You want to, really keep it tailored to who actually is an inventor. The more inventors you list to, the more opportunities there are. Even if they have an agreement to assign rights, it's not automatic. They actually have to execute the stuff. So the more you put on, the more you increase your risk of not having an inventor just cleanly assigned, and then you have to go through steps to make sure that they get it over to you. It just can introduce opportunities for error, and whatnot. What do you think, Doug?
Yeah, and again, in the US, which is very strict about inventorship, if you have over-inclusive inventors, you risk the chance of patent invalidity. So you don't want to just sprinkle inventors, like salt or pepper on the patent. In other jurisdictions, they're much more liberal about that, and it's more like, we'll call it, scientific journal publication, where you want to just give credit to people, and there are no implications for having over-inclusive inventorship.
Yeah, and then there's just what's the rationale to give equal rights for an invention with non-equal contribution? I think it's just a policy to just keep things efficient and clean and not have to argue about who has what share in a patent or not, and probably to encourage collaboration in the invention. I think some jurisdictions actually do dole it out ownership percentage wise, right, Doug?
Yeah, it's certainly possible to split things up, and we can talk a little bit about that later on when we get more into assignments. But in general, yeah, it's undivided, equal ownership.
Yeah. And then there was one of, have you ever added a patent attorney as an inventor? I've avoided that throughout every patent I've written. There's my questions are to articulate the invention and understand, not to contribute.
I, as a patent attorney, have never added my name. I do know at least one attorney who lists himself on a lot of patent applications, but I think that is justified because that individual definitely is very active in the technical, the R&D parts of it. So I think that's fair.
Yeah, so should we do the hypos?
Okay, good. So to our audience, feel free to comment in the chat box, or the Q&A box, preferably the Q&A box, as we go through these hypos. But Ryan, since you're right there and I can see you, I'm gonna pick on you. So hypo number one, Mr. or Mrs. Smith conceives of an idea for a new tool, builds the prototype, so there's a physical example of that, then files a patent application and claims the tool. So maybe kind of walk us through your thought process on who the inventor would be in that. Would it be Smith or somebody else?
Oh, it would absolutely be Smith. He conceived of the idea, even went through the step of building it, which again, you don't have to do necessarily. And then his patent application claimed it. So iron shut case, he's an inventor.
Yeah, I agree. What about any of the technicians or machinists? Why wouldn't they, be involved in that?
From Gosh, I feel like I'm going back to writing a law school exam answer based on these facts. They,
Yeah.
there's nothing saying that any machinist or technician actually did anything at all, and if they did, they certainly didn't conceive of anything, so they don't meet the standard of being an inventor.
Okay, good. I agree. And I see a few comments in the chat and Q&A that seem to align with that as well. So hypo number 2, our same inventor, same individual Smith now conceives of an idea for a new tool and instructs technician Jones to build the tool, and then they file a patent application that claims the tool. So again, who would the inventor be? Kind of walk us through your thought process
Yeah.
here.
So here again, you have the conception has been done by Smith, and the tool, the patent claims the tool that he conceived of. So he's certainly an inventor. Jones was instructed to build the tool. So it seems as though he only acted at Smith's directions and didn't contribute anything that made its way into a claim above what Smith conceived. So Smith is an inventor, Jones is not.
Okay, I would agree with that as well. And our third hypo, again, our favorite Smith conceives of an idea for a tool, a new tool, instructs technician Jones to build the tool. Technician Jones makes improvements on the tool. They then file a patent application, not only claiming the tool, but also the improvement. So who would be the inventor in that situation?
All right, so here Jones is now an inventor. Smith conceived of one idea that made its way into the claim. Jones followed those instructions, but also made an improvement or modification. And importantly, that modification or improvement made its way into a claim. Had that not been in a claim, he wouldn't be an inventor. But since his improvement is in a claim, he's now an inventor on this application. So Smith and Jones.
Okay, good. I think I agree with that as well. So we've talked a little bit about, who is an inventor and what are the requirements. And let's say you fill out some forms and you identify inventors, but sometimes we make mistakes. What can we do to fix those?
Well, there's two main mechanisms. One is you can go through the patent office with the Code of Federal Regulations. You can also go the federal court route and file a lawsuit under USC, or excuse me, 35 USC 256 to correct inventorship in an issued patent. And keep in mind that when we say correction of inventorship, that can be to add or remove an inventor from the list. Just by way of an example, this is what the output that you get from the patent office if you correct inventorship through the CFR. What it is, it's a supplemental application data sheet. And here you can see we've added inventor 3 and inventor 4, all in the underlined language that you need that is pretty typical and standard. And that's the output that you would get after you correct inventorship through the patent office.
And just out of curiosity, Ryan, how is it that you can show these documents? Some people may have concern about, confidentiality.
Yeah, of course. These are all publicly available. If you aren't experienced in looking up these types of documents, you can get them through a system abbreviated as PAIR, PAIR, and it essentially gives you the every piece of paperwork that's publicly available that's associated with a patent. And this is one of them that you can pull from the patent office's website.
Good, thanks.
If you do go the federal court route, this is just an example, again, of something we pulled from the public records of the judgment that names the inventors. Between the two options, the patent office route is the fastest if it's something that's kind of clean, not contentious. The court route is helpful. It can be kind of ancillary to patent litigation. It can be good for if there's a contentious dispute about inventorship, or if there's facts that need to be developed. Just two options to use for whichever suits your needs best. So that closes out inventorship for now. So we'll move on to the other half of our presentation of assignment. Assignment's relevant to the ultimate ownership of a patent. As we mentioned before, in the United States, ownership of a patent vests immediately in the inventors. Absent anything to the contrary, they're going to be the owners. In reality, though, if you've looked around at other patents, you'll see most of them are owned by companies, universities, some entities other than individuals. That's done through a mechanism of assigning, the inventors assigning their rights to that entity. In most scenarios, if you're an inventor and you work for a company, or if you're a faculty member at a university, graduate student at a university, somewhere in your employment agreement, there's a note that you're obligated to assign rights in any of your patents to the company, so that they automatically, well, not on, they're entitled to become the owner of the patent. They're entitled to have you execute an assignment to them. Note that assignment, it's contract law essentially. So unlike some other areas of patent law, ownership is for these purposes can be controlled or have an aspect of state law in them.
Yeah, and I think that's really important to emphasize. Just, some aspects of inventorship, ownership, assignment, all that may be federal, and other aspects are state controlled under state law. So you got to really watch out for, pay attention to that.
Yeah. And so on the ownership, like we just mentioned, that if you're hired as an inventor, oftentimes you're obligated to assign your work to your employer. There are some kind of other iterations or things to be aware of. In some cases, if you don't have an obligation to assign in your employment agreement, yet you used your employer's resources to help you with your invention, and especially if the work was within the scope of your employment, your employer might not ultimately force you to assign, but they might have what are called shop rights, which is a implied license to make, use, and sell your invention without fear of an infringement suit. Kind of a sticky issue, but something to be aware of. So just because you don't have an obligation to assign, don't think that you're necessarily out of the woods. There might be more facts to be aware of. If you're a corporate officer, so you're not hired necessarily to be an inventor, but say that you do some inventive activity and figure something out, you might actually, this gets deep into corporate law, but you might have a fiduciary duty to assign your invention to your company. At the end of the day, though, if you are an officer of a company and you want to make sure that your IP that's developed with your company is protected, or you're an employee, just make sure to check your employment agreements, or make sure when you're drafting these up that you account for your IP, because this can have some major consequences for how your IP assets are ultimately owned. Also, if you're a contractor or a consultant, just because you don't work for a company per se as a permanent employee, do watch your consulting agreements to see how any IP that might be generated during the course of your consultancy is divvied up. So ownership, I mean, it's a fair question of, why do we care so much? Well, joint owners of a patent have equal and undivided rights to make, use, offer to sell the patent. Importantly, they can do whatever they want with it without consent from the other joint owners. So imagine in a scenario where you have 4 inventors on a patent, and you've got 3 out of the 4 assigning to company A, but the 4th one doesn't want to assign, or forgets to, or just hasn't assigned for any reason. That could really screw up your business plans later. Say that company A was planning to do an exclusive license with company B, but then that rogue 4th inventor decides to sell his rights or assign his or her rights in the patent to company C. Well, that undercuts the value of that exclusive license to company B. So you really have to make sure that your assignments are buttoned up, and that anyone who is an inventor has assigned fully to that company. And it's also something that if you're acquiring a patent or a portfolio, that you want to make sure that everything's tied up, and that every inventor has assigned their rights in the patent to that company, and that there isn't that possibility for someone to go rogue, if you will. I think, and Doug, with that, can you, I think this case talks about some of the consequences of not having assignment buttoned up.
Yeah, definitely. So you just used the word going rogue. I think this is a good example of going rogue. So this is kind of the classic case where you have this, missing inventor that pops up out of the woodwork, Ethicon v. US Surgical. So for those of you who aren't familiar with those companies, Ethicon is the division of Johnson & Johnson that I believe is primarily responsible for sutures and some of their endoscopic products. And US Surgical was a big also surgical company mainly involved in endoscopic products, if I recall. I think US Surgical has now been absorbed into Covidien, if I recall. Anyway, so there was a patent infringement suit. Ethicon sued US Surgical for patent infringement. And it turns out there was an omitted inventor on that patent. That omitted inventor somehow got wind of this patent infringement suit, contacted the defendant, US Surgical, and ended up licensing his or her rights to that patent to US Surgical. So of course there was litigation to determine all of that, and the court did find that there was an omitted inventor for sure. And because the omitted inventor did license his rights to US Surgical now had rights to that invention. And so US Surgical was not infringing the patent. And therefore the case was dismissed. So Ethicon was unable to sue their competitor, US Surgical, because this omitted inventor popped up out of the woodworks, assigned his rights to the defendant, and then the defendant now was able to practice the invention without fear of patent infringement. So again, it's really important to identify the correct inventorship. It's really important to make sure all the inventors have assigned their invention to the right entities. Otherwise, you can get it in a situation like this. Then on slide 30, we go into another very interesting issue, and I can't even claim to know the answer to this, but I just want to mention it because I think it is very intriguing, and that's community property and how that affects intellectual property ownership. So as our audience knows, some states like California are community property states. So any property acquired before marriage is separate property. Any property acquired during the marriage is considered community property, and community property is evenly divided between the parties upon dissolution of the marriage. How does that apply to patents? If we go to the next slide, there was a case, the Innovis Nextel case. So the plaintiff Innovis sued Nextel for patent infringement over some GPS technology. The defendant Nextel then argued, hey, you can't sue us. You don't have standing because you didn't get consent from all the patent owners. They weren't all joined in the lawsuit. And then Nextel also argued that the reason that not all the owners were joined in the lawsuit was that the inventor, his ex-wife, should have been a co-owner on that patent based on California community property laws. Fortunately, this one was, I guess, pretty straightforward. So the court held that during the dissolution of the marriage, the California state court issued a divorce decree, and that resolved ownership of all the property, and both parties signed it, and therefore there was no issue about ownership of the patents, even though the patents were not, I don't believe the patents were specifically enumerated in that divorce decree. The court said, well, you guys settled all the property issues, so there's no issue about, who owns the patents. So, in this case, things were relatively cleanly resolved, I guess, but it still does, leave the issue about what if there was no divorce decree? What if we're talking about a couple that's still married? If one of the spouses invents something, does the other spouse still have some ownership in that? So that's a very intriguing issue. Now this, I think we'll just have to kind of watch and see how the courts handle this if these issues are raised in the future. But it's certainly one of the privileges of living in California. We'll leave it at that. Okay, so let's talk a little bit about assignments. So again, we've talked about some aspects of inventorship and assignment being controlled by federal law. Some aspects are controlled by state law. At its core, assignment is contract law. Contract law is state law, right? So contract law, for our attorneys out there, you'll remember from your lovely Contracts 101 class that a contract consists of an offer, acceptance, and consideration. So these are typically bundled in the employee's employment offer. So there's typically not a separate contract. So your consideration is typically, your salary. Sometimes inventors will get the nominal peppercorn or $1 for assigning the patent to the company. I am a named inventor on a few patents. I never got my $1. I'm still waiting for it. But so I assume that my salary was considered the consideration in that transaction. But let's look at some of the mechanics of assignment. So if we scroll over to the next slide, please. Thank you. So this is a typical assignment form that a lot of law firms will use. And I'm sure a lot of people in our audience will recognize this. So a couple things that we want to identify. So in the first paragraph, you'll see this the arrow on the top right-hand side. It identifies the property, which has the serial number of the patent application and the title. So obviously you want to identify what property you're assigning or transferring ownership to. And then this first arrow on the left, we talk about for good and valuable consideration. So remember, contract law requires consideration, meaning compensation. And then the next arrow on the left kind of highlights the fact that we are conveying, assigning, and transferring to this company the patent that's listed above. So what we look for in that situation is what's called a present assignment clause, not a future. So in other words, the assignor, the person who's giving the property away or selling it or transferring it, does transfer it in the present time, not in the future. Because if you say, I will transfer it, that could be any time in the future. So that's not really going to help you. You want the transfer to be in the present time. So present transfer clause is required. And then in this next paragraph below where we see the red arrow, oh, sorry, go back. Thank you. The second red arrow on the right-hand side, that's talking about other patent family members, including divisionals, continuation applications, continuation parts, foreign counterparts, et cetera, et cetera. So again, you don't want, typically, you could, if you want, you could just transfer one patent, but typically we assign patent families. So that means the one patent of interest and then any foreign counterparts, any continuations, divisionals. So that's the point of that paragraph. And then the last red arrow on the left is also important for countries such as, or jurisdictions such as EPO, the European Patent Office, where you want to specifically enumerate that you are transferring the right to claim priority to the present from of the present application back to any earlier patent application. So if you don't transfer the right to claim priority, then you would lose that priority in some foreign jurisdictions such as Europe. Then the next slide is just some more language, boilerplate language that we'll just kind of skip through. And then if we go over to slide 36, you'll kind of see in the US, typically we only get the assignor signature who is assigning, meaning the owner assigns it to the company in this case. There is no acknowledgement or execution by the assignee, the company, because it's not required. There's no notarization, there's no witnessing, because those things are not typically required in the US, but you should be aware that in different jurisdictions, they may require notarization, a witness signature, or acknowledgement by the assignee. So like, for example, in Europe, typically you need the assignee signatures. So be aware that, one assignment form may not work for all jurisdictions and you may have to modify the form. So it's best to talk to your, foreign counsel to make sure that these forms are correct. So Ryan, we've got a invention, we've got an assignment form signed or executed. What do we do next? How do we perfect assignment? And what is perfection?
Well, yeah, I'll go through that. It looks like I've got about 10 minutes or so left, so I'll kind of try to speed through it a bit. But perfecting assignment essentially means recording it. If the assignment's executed and sitting on your desk or in a file alone, it's not going to do too much for you. What you really have to do once it's executed is record it with the patent office. It's analogous to if you buy any property, house, piece of land, whatnot, you're recording it with the county registrar. The reason being that the patent policy wants you to provide notice to the public of who actually owns the patent.
And we
Once you
should
do,
just talk very briefly that, in some jurisdictions like the US, electronic signatures are acceptable. You can use DocuSign or Adobe Sign. Most jurisdictions that I deal with accept electronic signatures, but some jurisdictions do not. So again, you have to be aware of where you're working.
right, that's a good point. This is the output from the patent office. If you do, once you do record your assignment with them, this is publicly available for anyone to search, and you can track the transfer of the patent between inventors to entities and between entities as well. Perfecting the assignment, again, it's pretty important. And it's even more important to do it timely. I mean, I try to get these things recorded same day as they're executed, and at a maximum like the day after. The reason being that if you don't record it soon enough, if somebody else records an interest against that before you, your claim to ownership can be impacted quite negatively. So the take home about assignments is don't just execute them, make sure you get those things recorded as soon as possible. Stepping back to getting the assignments executed, that's also something that you want to do as soon as possible. Inventors can change jobs and be difficult to track down to get their assignment, even if to get their signature, even if they're obligated to assign to the company. They might be disgruntled and not want to cooperate. Again, even if they're obligated to assign, it gets cumbersome to make them do it. There are some mechanisms to sidestep that if you absolutely can't get a signature, but it's just best to avoid it completely. In some cases, I've had where an inventor has died before having the chance to execute. It's just stuff that you want to do as promptly as possible. Make sure that you're overly inclusive of assigning patents in a chain. So going all the way from a provisional to PCT to a national stage entry, it's good to have assignments at every step. It keeps the chain of title clear, and it also in some cases, particularly in Europe, can help you to establish your priority claim all the way back to its earliest. So it's something that you really want to make sure that you do anytime you get a patent on files. Make sure the assignments are buttoned up and ready to go. Correction of assignments, errors happen, and there are plenty of mechanisms to get it fixed. The most common are simply misspelling of an assigner or an assignee's name. Wrong company name's a big one. Make sure you know exactly what the entity of the company is. The comma between a company's name and Inc. is a big one that you'll see. Inc. versus LLC versus PA versus whatever. Just make sure that you have that matched up. Sometimes I've asked, to see to the extent they can show me articles of incorporation just to make sure that I get that ship shape. You can get the wrong patent number. You might, as a typo, list application other than the one you intend to assign. This can happen on your end. Sometimes it can happen that a third party might accidentally list your company's name on the assignment, and it can all be fixed. But it's just stuff to be cognizant of and make sure that your portfolio is in good shape. If you ever go to try to monetize your patent by selling a portfolio, this stuff will come up in a due diligence. It most certainly will be found, and it's something that could delay a deal or in a worst case kill a deal. So you really want to make sure that your chain of title is clean and free of any questions. So here's some hypos about some common errors in assignment, and I'll ask Doug if it makes sense to let it ride or get it fixed, and if so, how. So Doug, inventor Jonathan A. Jones, say that's how he's listed in the application data sheet, executes an assignment, but in the assignment his name is John A. Jones. What do you think?
Well, it could be okay, but I like to cross the T's and dot the I's. So to me, I always try to go with the full legal name so that there is absolutely no doubt that Jonathan A. Jones is John A. Jones. So we would, if the assignment was executed with John H., the abbreviated name, I would either file a corrective assignment, or I would just have him initial and date and put his, full name on the assignment form.
Okay. How about inventors execute an assignment to ABC Inc., but the company is actually ABC LLC?
So they are two different legal entities. So assignment has, the way I interpret this is assignment was to the wrong entity and therefore it should be corrected.
Okay. Inventors assign patent application to ABC Inc., and then ABC Inc. is acquired by XYZ Inc., but there's no assignment between ABC Inc. and XYZ Inc.
So probably there is, some kind of merger document or acquisition document between the companies. So that's probably good enough. But again, it's just good to record these things on the PTO website so everyone can see them and they're public. So I would definitely make sure that there's an intercompany assignment that's recorded on the PTO website.
All right. And then, oops, the other one was 2 of 3 inventors assigned to ABC, but the third never executed an assignment.
Big problem. So again, you have that, that potentially rogue inventor. So you better get inventor number 3 to assign.
All right. So I'll turn it to Doug to show how to actually correct an assignment should that be necessary.
Okay. So fairly straightforward. Again, we're just showing you some public documents here. So it looks like in this particular example, there was a typo in the company's name. So we just, we added the correct company name, correct spelling of the company name, and had all the inventors initial and date to change. And then we re-recorded this as what's called a corrective assignment, and then problem solved. Let's see. So next slide. So as Ryan mentioned, sometimes you can't get inventors to execute the assignment. Sometimes they quit, they may be disgruntled, sometimes they pass away on, untimely. So you kind of need plan B. So a good idea for company is always to, again, have these employment agreements or consulting agreements that have an invention assignment clause. Basically, says that you've been hired to invent and the company owns any inventions that are related to, your job function here. So if you can't get the actual inventor to execute the assignment form, you can often record these employment or consulting agreements and demonstrate that there is assignment. So that's kind of a backup plan. And then let's talk just very briefly about assignment and licensing. So, again, assignment relates to ownership and licensing relates to not owning it, but having the rights to use the technology or the patent, the invention. So the analogy that I like to use for this concept is, assignment is when you buy the car, you buy the shiny red car and you own it. Versus you either rent it from Hertz or you you lease it from the dealership. That would be equivalent to licensing it. And then if we just go to the next slide, some more comments about assignment versus licensing. So in both assignments and licensing, you can kind of define what aspects of the invention you want to assign or license. So the analogy I like to use is a pie. I'm not sure I would actually eat this pie because it's kind of a very unappetizing green color. Unless it's a key lime pie, then of course we will eat that because everybody likes key lime pie. But you can slice up, the pie any way you want, into big slices, little slices. They don't have to be triangular slices. They could be, squares or circles or any geometric shape. So the point being that you can divide up the property any way you want. So, in a license, you can license based on a field of use. You can license based on a geographical territory, time limits, et cetera, et cetera. Another analogy is a house, right? So you could sell the house, you could sell, part of a house, you could rent a house, you could rent a part of a house. You could rent the house for just a portion of the year. So same thing with assignments and licensing is you have to set up the terms of those things. And then just the last slide that I was going to put up here, we were planning on doing a demo of some of the stuff on Pair. Obviously, we're out of time now, so we won't be able to do that. But a lot of these things you can see on the PTO's website, Pair, which is patent application information retrieval. So anything that's publicly available, you would be able to see it there. There's also their database AOTW assignments on the web, so you can pull up and look at that stuff. So we're actually out of time. So I do want to thank all of our attendees. We had a fantastically large crowd, several hundred people on today's webinar. So thanks for taking the time. I know we didn't get to all the questions. We will try to address some of those offline. But thanks Ryan, Michelle, and Brianna for helping us put together this webinar, and hopefully you've found it useful and informative. So have a good day, everyone. Bye.